You may have just seen in the news that Tommy Robinson received a sentence of 18 months imprisonment for contempt of court. But that's not true, because he didn't. And I will explain why very shortly. Don't get too excited about this, it's just a very technical thing. But first of all, what's all this about? Well, just to get over some of the confusion, Mr. Robinson currently is in bother for two things. The contempt of court, but there's also, he's also been charged with not giving the PIN number to access his phone. That's a completely separate issue, and that will no doubt be dealt with in due course. But I want to talk about this contempt application, because I've got the judgment now, with the judge's full remarks, and they're quite interesting. So, first of all, what's this about? How did this originate? Well, and I can look down to read these, this all started with a defamation case. There'd been a story where a schoolboy had been attacked. And Mr. Robinson said, well, this was because this guy had got to all sorts of dodgy things at school and himself was, involved in violence and was an aggressor. But the young lad sued, and Mr. Robinson lost that case. It was proven in court, as far as the court was concerned, that the allegations were not true. So Mr. Robinson was found, well, liable for the defamation. And he was ordered to pay £100,000 to this young lad and the costs. But also, an injunction was put in place. Now, that's very common with defamation proceedings. Like I say, it's almost impossible to get an injunction before a trial in defamation. We have this doctrine of no prior restraint. Bonnard and Perryman, if you want the actual case. But, it's the old publish and be damned. But once the case has been concluded and the court has found that the allegations were defamatory, then they put an injunction in place saying you must not repeat these allegations. And that injunction stays in place forever unless you can make an application to set aside that injunction. Say down the line some further evidence came out or something like that. But that didn't happen in this particular case. But Mr. Robinson made a film about this case where he repeated the allegations. And, he broadcast this in various meetings and including in Trafalgar Square. So lots of people saw this. But breach of an injunction is a contempt of court. Now, as the judge explained in this case, that's not, he actually said the language is a bit clumsy and unfortunate, because it's not contempt in the sense that, it's actually anything against the court. It's a refusal to comply with a court order. A refusal to comply with court orders are in themselves contempts. And they said there were 10 separate incidents that amounted to contempt of court, but they actually brought them in two applications. Who brought this application? It was actually the Solicitor General. So in this particular case, the Solicitor General is the applicant. Mr. Robinson, as it says, well, actually, it was done in his Stephen Yaxley Lennon name, aka Tommy Robinson. Just as a little aside, when it comes to initiating legal proceedings, there's no actual obligation to use a person's real name. You have to identify who the parties are. But say, for instance, there's a classic case where, I remember because when I used to work at the newspapers, the one thing I could always say to my ultimate boss was, well, you're responsible for the world's largest defamation payout. And that was on behalf of, it was a Mr. Reg Dwight. But of course, he sued in the name Elton John, which is, his stage name. And it's the same thing here. So in terms of the name, they brought the application against Stephen Yaxley Lennon, but it actually says in brackets, aka Tommy Robinson. But the claimant was the young lad himself. So there were sort of three parties to this, although he himself did not actually take part in this. I mean, he could have done. It's always open for the person who the injunction is protecting to bring proceedings for contempt on their own behalf. But also the Solicitor General, acting on behalf of the Attorney General, they have a public interest in making sure people comply with court orders and don't publicly breach them. Because, the idea is we need to ensure the rule of law. So it was actually the Solicitor General who brought the claim. And it was actually two separate claims, because they initially brought one over some breaches, and then Mr. Robinson made further breaches. So they actually did 2 applications, but they rolled them up all in one. So the judge looked at this and said, well, okay, you've got your Article 10 rights and things like that, but because the injunction is in place, we don't go and revisit the facts of the injunction. You can't argue that the injunction itself is wrong. That you've had another opportunity to do that. That was something you could have done after the defamation trial. So as far as the court's concerned, that injunction is there and they don't go behind it. So the only issue was, were there any breaches? And actually, Mr. Robinson admitted, yes, he was in breach of the injunction. I mean, there's probably not a lot he can do about that. So when it came to sentencing, the judge said, because the interesting thing about contempt is, like I say, even though you are sent to prison, you are not sentenced to a period of imprisonment. That's something you get done if you have committed a crime. You are sent to prison. Prison is, the punishment, the deprivation of liberty. And although a contempt results with you ending up in prison, technically speaking, it's not a criminal offence, even if it is a criminal contempt. And I've explained this before as well. We have civil contempt and criminal contempt, but it's rather confusing. You can commit a criminal contempt in relation to a civil case, and you can commit a civil contempt in relation to a criminal case. It's all to do with the level of the, quotes, offending. I mean, say for instance, you're in a criminal case and you fail with your disclosure obligations, you're a bit late serving something. Well, that is a contempt, but it's dealt with as a civil contempt because it's procedural. But let's say you're in a civil case and you bribe some witnesses or intimidate some witnesses, even though it's a civil case, that crosses the threshold into criminal contempt. So here they regarded it as effectively a criminal contempt. And interestingly, they compared it to a criminal behaviour order. A criminal behaviour order is something you can get at the end of a criminal trial, where they can say, right, we need you, we're going to put an order in place to minimise the chance of you re-offending. And it could be something like not to associate with certain people, not to go in certain areas, not to have access to the internet or use electronic devices. And the maximum sentence penalty there is 4 years, whereas the actual maximum penalty for a contempt of court is 2 years. But here the judge looked at, the relevant guidance and said, actually, this is about as worse a case as you can get, because Mr. Robinson was blatantly saying, I don't care about the injunction, I am going to do this. So the judge said, I will impose the maximum of 2 years. But also we have this totality period idea that even though there were 10 separate breaches, the judge said, well, I'm not going to sentence him individually on each one, because that would, take it beyond what is actually a reasonable punishment for this. So the judge said, I will just impose the one sentence. And the sentence initially was, the maximum is 2 years. The judge said, okay, there's a bit of a discount here, there's certain bits of mitigation. But interestingly, Mr. Robinson spent 3 days in prison awaiting, on remand effectively. I mean, it's not remand, you're just being held. Technically, just to be, my favourite nerdy thing, he was technically being held in jail. I mean, physically he was being held in a prison. But as I've said before, all jails are prisons, but not all prisons are jails. So it served three days. So the judge imposed a sentence of 18 months initially, but because, unlike in a prison sentence where time spent on remand automatically is knocked off, it actually isn't with the contempt. So the judge said, I will knock off 3 days. So technically he's been sentenced to 17 months and, 1 month minus 3 days. I mean, a lot of that will depend on just how the calendar works out. It's almost, it's a bit weird that, it's like, if your sentence crosses a leap year, you spend a day more in prison than somebody else would do. There's a great book, Day in the Life of Ivan Denisovich Shukov by Solzhenitsyn, all about a day in a Russian gulag. I always like to read that when I'm cold and I'm too tight to put the heating on, because I read that and go, well, at least I'm not in a Russian gulag. But the last sentence there is, there were 3,653 more days like this, the extra 3 were for leap years. And, that's what can happen here. So it's a bit luck of the draw. But yeah, effectively, he will serve 18 months. He's been sentenced to 18 months minus 3 days. So I can see why people have rounded it up, but that's technically not correct. I mean, he also got a bit of a discount for actually pleading, because in the same way that in a criminal case, you get a discount. The earlier you plead, the more you get off your sentence. If you plead at the earliest opportunity, you get 1/3 off. what they said here is pleading effectively on the day of the trial will do what they do in the Crown Court, which is, okay, you get 10% off. So that's why they rounded it down a little bit as well. He'll be released after serving half of that, because the same rules apply. You serve half the sentence. Now, interestingly, the judge also commented about, we've had directions from the government about how full the prisons are and all this early release scheme. And the judge was quite sceptical about that and said there's actually no evidence whatsoever that the early release scheme has actually freed up any prison places. But you know what? I'm not even going to think about that. I am just going to sentence him to what I think he should actually get. There are no licence conditions, though, on something like this. Once you are released, unlike in a regular prison sentence, when you're released halfway through your sentence, or sometimes after 40% now, you are still subject to licence conditions. I mean, some are just basic, like, you mustn't commit further offences or re-offend, but they can actually put specific conditions on again, like do not go near certain people, do not engage in particular behaviour. And if you breach those conditions, you are hauled back to court. Hauled back to prison. But in this particular case, the judge said, well, I don't need to do that because the injunction is still running. So if he's daft enough to do this again in future, then he can just be hauled back and it's a further contempt, because it wouldn't be double jeopardy or anything. I mean, people say, oh, double jeopardy, that's, you can't be done for committing the same offence twice. But it's the same factual offence. I mean, there's that film, where the lass gets falsely accused of bumping off her husband, and then she realises that now she's been tried for that, she can actually do it for real because she can't be sentenced twice. That's not how it works in real life. It's not the same, like, offence by name. It's the same offence arising out of the same facts. He's got an automatic right of appeal for this. You don't need leave to appeal to appeal against a sentence for a contempt. You've automatically, or indeed a conviction for attempt. Unlike most of situations where before you can even appeal, you need leave to appeal. In this particular case, you don't. But the other interesting thing is the costs. The Solicitor General sought £80,350.82 in costs, and has asked for what we call a payment on account of £50,000. Because what the judge will usually say is, I make an order that the respondent pays the applicant's costs, loser pays winner's costs, subject to assessment if not agreed. And they go for detailed assessment, and I've done a million videos on that. But you can actually ask for a payment up front, because you can say, well, even if this is assessed, and we get knocked down a bit, the bare minimum we're going to get is this amount. And they've asked for £50,000. The judge has said, I'll deal with that on the papers, put in your submissions as to why your costs are reasonable. But yeah, I mean, the judge has actually said, you are going to pay those, but you've got 7 days now to put in writing, how much, what the interim payment should be. So that's pretty much it, really. But yeah, I just wanted to, make sure there were no misconceptions about this. Because like I say, it is all very confusing. I've seen people getting it confused with the not disclosing the telephone PIN number thing. But there you go. So yeah, when, if you're down the pub tonight and people are saying, oh, Tommy Robbins got 18 months, you can say, well, actually, and correct them and be all pedantic and nerdy, like I've just been. But anyway, as always, hope you found that vaguely useful, vaguely interesting, vaguely accurate. I'm indoors today because it's just so miserly outside. And also I've got some actual work to do, grumble, 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 so I couldn't skive off somewhere nice to do this video. But hopefully, when the weather clears up, I'll be out and about in some nice locations for you.